Are we ready? Bueno, buenos días.
So, good morning to everyone. In my position as a director of the International Insolvency Institute, as well as co-chair of the Latin American Regional Committee with Fabio Rosas from Brazil, of this very same institute, I'd like to welcome you with this series of 3 webinars that this institute is organizing of the International Insolvency Institute, together with the World Bank, where we will be trying to, in these 3 days, today and the next 2 Thursdays, this topic on the simplified regimen of insolvency for small and medium enterprises. So just as a reminder of the structure,
reunión de hoy vamos a abordar la perspectiva luego de una exposición inicial
as an initial participation
delegado del Banco Mundial en este webinar.
The World Bank delegate in this webinar, we're going to be looking at the perspective from Brazil and Argentina. Next Thursday, the 23rd of September, we will be looking from the viewpoint of Chile and Colombia, and we will end the next Thursday on the 30th, looking towards Mexico and Peru. The structure in the 3 webinars will be a structure which will be very similar. We will first have a presentation by Andrés Martinez, who I will now briefly introduce, and then we will have a moderator in this case of today, which is myself. So we will precisely organize the presentations of 4 panelists, 2 for each one of the countries mentioned. The idea is that at the end of the initial presentation by Andrés and of the participation of the 4 panelists, we will have 10 to 15 minutes for us to be able to have a Q&A of the panelists. So I am presenting Andrés Martinez. Andrés is an attorney for over 20 years of experience, has a master's in corporate law, and specializes in insolvency and the rights of creditors, works as a senior specialist in the financial sector of the World Bank, which he joined in 2008. In other words, for over 1 decade, Andrés has been advising countries in Latin America and the Middle East and Europe and Asia on legislative reform in terms of recovery debts, specifically insolvency laws, and the renegotiation of liabilities. He's a member of ISOL International and co-chairs the working group on insolvency in the World Bank, and also the regulatory symposium together with the World Bank, ISOL International. We see the efforts being made by the World Bank for over 20 years now, but in recent times there are concrete products which are tangible and deliverable in terms of special insolvency systems for small and medium enterprises, and then obviously, we will have the panel of 4 very qualified speakers, 2 from Brazil and 2 from Argentina. This is just to give an initial kickoff to the importance of what we will be dealing with today, and obviously exclusively taking into account the official estimates from Argentina, although I suppose that for the rest of Latin America, the data will be very similar, and as well as for the rest of the world. In the case of Argentina, they represent over 70% of employments registered in Argentina, and they represent nearly 50% of the GDP. This is of June 2021. In other words, these are data that are resulting from the huge impact that the COVID pandemic had on SMEs. Andres, thank you very much for sharing your time and your contributions with us both today as well as in the next 2 Thursdays. I would now like to give you the floor. Thank you very much. Thank you, Javier, for this very kind introduction. It is truly a great pleasure and an honor to make this event together with the International Insolvency Institute, and also a great honor to introduce to speak to this audience with these panelists who we know each other for such a long time. In fact, one of the reasons why the World Bank strengthens itself in this topic is due to the absolute importance that SMEs have for everything, basically, but essentially for the development of a country. I would like to share a few slides very briefly, where basically we're going to be trying to, but let me just see if I can make the technical miracle that this can be well seen. Can you see my slides well, Javier? I can see the slides very well. Okay, let me see. I don't know what's happening here with my computer, but let's just try to do it like this. We started with 3 reasons why we're focusing on the insolvency of micro and small and medium enterprises. The first, obviously, is for the development of a country or global development, right? And the second is the huge impact that COVID has had. And in point of fact, this has been unproportionately severe or hard on the SMEs. And finally, there's a belief, which I believe is very much justified, which is that the traditional insolvency laws, as we know them, are not an instrument, I don't know if appropriate is a word, but they are not ideal to deal with SMEs. At a global level, they represent over 90% of businesses. And this are bigger than the numbers that we had for Argentina, for example. This is incredible to see the contribution that they have for global development, not only in terms of the size of businesses, but also employment. For the World Bank, employment is an essential tool to reduce poverty, and the MSMEs represent over 50% of global worldwide employment. And I'm not even talking about obviously emerging markets. This is even bigger. If this is something, a publication with a different numbers, and I believe everyone in this panel agrees on the importance of SMEs. With the pandemic, what has happened is that the pandemic has started in this sector. So if we look at the prior crises which have occurred, for example, those in the United States, Argentina has a very large number of crises, of their own crises. Many times the crises start in the financial sector, but in this case, it started at what was called the lockdowns, right? And it started in the real sector. And this obviously has affected in an unproportionate manner, in a disproportionate manner, the SMEs, the MSMEs, and they contribute specifically to the service sector, to hotels, transportation, etc. And above all, there are not enough resources to stay alive, and they don't have access to financing during the pandemic. And that's something that the big companies can still have access to these funds. So we are in a situation where many people ask themselves, will there be a wave of bankruptcies, or is this something which will not happen? So the answer to this is, it's uncertain. We have seen all types of is my screen still being shared? I'm sorry. Yes, yes, Andres, we can see your slides. Okay, perfect. Thank you. So, as I was telling you, the key question is here, will we have a wave of bankruptcies? And this is the question that we have seen. We have seen a very big number of analyses being published on this regard. And the reality is that all the aspects that at the beginning was saying you're going to have a wave of bankruptcies, this hasn't confirmed. And this hasn't been confirmed for many reasons. And the first is that in many countries, there was an injection of money into the economy by the central bank. And therefore, we already have a mitigating factor which has avoided a wave of insolvencies and bankruptcies. And the other aspect which took place is an uncertainty by the financial creditors, in the sense that if they start to enforce all the debts, they will have a very big number of defaults and lack of payments, which they won't be able to handle. And this has contributed for this to not escalate and to not have a big wave of insolvencies. The third, and this is where we have started on the topic of insolvency laws, is that the SMEs have a natural trend to avoid formal insolvency proceedings. Sometimes they just can't do it, but the reality is that they don't have many incentives and very little capacity. They don't have enough information in order to be able to present themselves many times in these complicated processes which take into account the insolvency laws. And another issue is what we call the passivity. In a very large insolvency or in a big restructuring, the creditors already have significant interest in actively participating in trying to make that company recover. But in the small and micro cases, that just doesn't exist. The creditor waits and many times co-participates. It might not be that the experience in Brazil and Argentina, but that is an issue which has been identified prior to advancing with this process. So everything which is access to financing during the insolvency and after the insolvency is very difficult. Many of the SMEs and MSMEs have some type of super exposure in terms of the debts which are created by for personnel and by the company itself. In many cases, we have the lack of assets to be able to solve the insolvency, and sometimes the trustees, etc., as you would call them in Argentina, those in general have problems to receive the money because there's just not enough assets to receive it. And this is something which goes a little bit ahead of what's going to be said. In the analysis that we have made, the small and medium, the medium-sized enterprises have a little bit more access. And that is why many times the suggestions that we give in the principles of the World Bank, which have been changed this year, is for SMEs only. And we leave it up to each country to decide if this is something which is also applicable to the medium-sized companies. But as the definition is so different between what is micro, what is medium, what is average, what is micro, small, and medium, even within a country, there's different definitions, sometimes determined by the corporate law, sometimes by the insolvency law. And we have decided to leave that up to each country to decide. And today there's a trend in comparative law that tries to shape the insolvency systems, the standards that we have for the small and medium-sized enterprises, trying to, as we have mentioned, to simplify some formalities, some requirements, or directly to have a specific law for the SMEs. And this is exactly what has been done by Korea. This is what is being suggested to be done by Spain. While we're talking at this moment, there's something that we have been looking at. This is something which has been developing. And there's also a lot of work by the international organizations looking towards the international standards. Since 2017, we have been working on an analysis where basically we have seen these problems, these challenges that are special for the SMEs. Some are also applicable to the big companies, but they're more acute in the SMEs. And we also have some proposals in 2018, 19, and 20, where we have many round sessions and working sessions, which finally end in April of this year with a publication of the principles of the World Bank, something very similar, which is being done by UNCITRAL, working on their legislative guide, where they also make recommendations. And to wrap up, I'd like to show you some of the principles that it's when we start to see the development of these legislations. But basically, we are talking about minimizing the formalities that exist in many cases. We talk about institutional considerations. It is truly essential to have the manager that generates more costs. Yes, you need someone that supervises, but is there a way to put this into a different system, which is cheaper, that doesn't require to have a trustee or someone who has an additional pay? How do you usually convert these processes and vice versa? So an aspect where we have eternal discussions with our colleagues from the IMF, UNCITRAL, the UN, and with many specialists is, have we had proposals to directly eliminate the reorganization votes? This is something which has been taken into account a lot. But yes, where we have seen convergence is that the lack of the votes are implicitly considered an approval in the case of micro and small companies. We're not talking about medium size or large size. And this is obviously something which I believe that both in Argentina and this is something which is done by the debtor with a possibility of some supervision, but not the removal of the debtor from the total control of the company without differentiating the companies, as we have seen in some legislations. And finally, a topic which is of great importance, which the European Commission has been working on lately, is in guaranteeing what we call the fresh start of the debts of the individual debtor. This is crucial. To think that an individual entrepreneur will be stuck with debts for the rest of their lives, this is to remove from the field of play a crucial player in trying to contribute to the economy. So if there's no fresh start, the debts obviously are something to pay the maximum pays of his debts and the credits. This is something that you could also have a period of time during which you should continue repaying these debts, but to put a full stop and to guarantee that this entrepreneur can continue operating. These are some of the considerations which have done both in the UN, the World Bank principles, which are recommended to the country. The World Bank works in many countries, helping them to reform their insolvency laws. I specifically have worked a lot with countries in the Eastern Europe and Middle East, and I continue to do so with countries throughout the world. So when I sit down with legislators and decision makers, these topics are topics which reappear, and obviously the legal reform is something which has different visions of specialists, sometimes from the banking associations and the trade organizations, because many times in our insolvency discipline, we have this unavoidable tension, which is the lack of a possibility of repayment. So we never make everyone happy, but that's how it is. That's how things happen. So now I'd like to give the floor back to Javier, Lorente, and thank you very much once again, Javier, for this exceptional collaboration between the International Insolvency Institute and the World Bank. I'm truly very, very enthusiastic of hearing the panelists. Thank you very much.
Thank you very much, Andre, for this presentation. I insist that although the World Bank has placing this webinar to available to the governments to talk about this topic that is so interesting and so important to all the governments. I understand that it is also in homage to Adolfo in this, because it's Adolfo Guillaume from the World Bank who initially started and did the kickoff for this idea, because really he is the one who thought that to regulate for the medium or the micro, medium and small enterprises doesn't have the glamour or the love affair that it has to regulate for the big enterprises, but nevertheless the importance of the maths demands it. Let us now insist, and I thank again Andres for your participation of today, and on behalf of the Tripline for the next 2 Thursdays. Let us now start with a panel. I am going to make a brief presentation of the other 4 panelists that I have the honor and the pride of coordinating today. We have Fabiana Solano. She is a lawyer of the Pontifical University, Catholic University of São Paulo. She is the partner of Felster Lawyers from the year 2011. She was the associate in the practice of insolvency in White and Kate in Miami. And while this partnership as a foreign partner, she was involved in several procedures of the Chapter 15 of the American chapter of insolvencies in Miami. For certain reasons, the Brazilian companies prefer Miami than New York for the Chapter 15 procedures. She is a member of the International Solvency meetings, and she was acknowledged by the prestigious publication chamber in the band 4 of insolvency and organization recovery. We also have Christina O'Reilly. She is the judge, national judge of in the city of Buenos Aires. She is an ex-university teacher in several universities and the author of several articles and chapters of books on commercial laws, as well as also bankruptcy subjects and the National Insolvency Institute and Sol International. Let us talk now about judges, and in addition to have an Argentine judge, we also have a Brazilian judge, an all well-known person we know, Daniel Costa. He is of bankruptcy from Sao Paulo since 2011. He is a teacher of business matters in the University of Sao Paulo through 2020 and 2022. He is the judge of the Superior Court in Brazil. And as a very important news. He is a member of the committee of jurists that participated and prepared the new act of insolvency and judicial recovery in Brazil. Daniel, if he has some time available, he will tell us of Conan de Barber. He is a member of the International Insolvency Institute, as well Insol International. And finally, but not less important, from Buenos Aires, we have on the side of professional practice, we have Fernando Hernandez, who is a lawyer and a lawyer, Marvar O'Farrell, and a member of International Insolvency Institute, as well Insol International. From this last, he has been a member for a very long time, and we join of Insol International, and he's also been acknowledged by the publication chamber as the very renowned lawyer of insolvency and restructuring, with other members too that I have seen him an eminent. He is he has a multiple knowledges. And as we had organized before among the four of us, we had decided that each one of the countries would make a first introduction if there are normatives in each one of both countries, and I refer to Brazil and Argentina, any regulations in their bankruptcy laws that covers the small and middle enterprises on these topics. And before giving the word to the panel, I would like to point out that one of the things that Andres mentioned very clearly, that none of the documents from the World Bank and UNCITRAL that in parallel is working, as Andres mentioned very clearly, in a simplified regime for micro and small enterprises. UNCITRAL is leaving aside specifically the middle enterprises. In Europe, in the European Union, there are indicators to the member states to cover this, each country obviously, and inside each one of the countries and the regions, as Andres very well pointed out. It is very difficult to decide what is a micro, medium, and small-sized enterprise, both in Brazil and Argentina, and in federal countries that have a very wide-ranging countries. It is very difficult to know the opinion of the panelists. What would be the precise definition of what a micro and medium and small enterprise would be? If you agree, we would start with Brazil. I don't know if Fabiana or Daniel would like to decide to explain the position of the solvency in small, medium, and micro companies in Brazil. Good morning. Thank you very good morning. It is a pleasure to be with all of you here today and to join the panel. In Brazil, there is a regulation or some specific norms in the law of insolvency to deal with the micro and small enterprises. Nevertheless, we had a very wide-ranging reform that was quite complete, that started and was under discussion over very many years. And due to the pandemic, it was accelerated. It is in force since January 2021. There are many different characteristics that have improved for the enterprises and for the creditors, but nevertheless, there is no specific attention dedicated to the micro and small enterprises. There are still very insolvencies that is very inefficient and very costly. This is a very great problem. Andres has also mentioned this, and the crisis is very wide. We believe that approximately 70% of the Brazilian families are indebted. This implies that the micro and small enterprises that are strongly related to the physical people or the individuals are very strongly affected, and there's no relief for these micro and small enterprises. Why? Because the procedure continues being very expensive, very bureaucratic, and very inefficient. What we do have in the specific norms of the Brazilian insolvency law are small aspects like, for example, the remuneration of the juridical administrations for the juridical recovery. That is Chapter 11 of the US law adapted to the Brazilian situation, and you have a cost reduction, but even this cost reduction is very, very timid. For example, the remuneration of this administration of companies that are not subject to the procedure or the situation of the micro and small enterprise, and that is 5% that is due to the creditors in the judicial recovery, or 5% of the products obtained of the bankruptcy go through from the products of this bankruptcy drop to 2%. There is a very similar procedure for the small rural farmers that have a debt of approximately 4.5 million reais, or the Brazilian currency. In addition to that, what we also have is that the requests, the debtor makes a request of the judicial recovery, and all the documents necessary required are presented in the lawsuit. And basically what we have is the possibility of presenting all the documents simplified. It's very, very simple, but there's also the possibility of making an installment of payment in installments in a special regime, and transactions that for the micro and small enterprises, you have 20% more time compared to the other enterprises. And the great change or innovation, if you want to call it like that, that is the difference in Brazil, the possibility of giving prepared a special plan for the micro and small enterprises to the creditors. This is a possibility, it's not compulsory, but if you are a micro small enterprise, you can present this plan, a simplified plan. What can present is the possibility of payments in installments of the debt in 36 installments with official interest rates in Brazilian currency and some discounts for a table, already decided by the government. But obviously it is not enough because the debt is still there and you have the possibility of paying in 36 installments. It is not something that is made of the capacity that the company has to pay. And it is a situation, quite frankly, very bad. It is not enough to solve or help the situation. There are some limitations because the micro and small enterprises would need some authorization from the judge to carry out expenditures. It is not the normal course of the business. The problem that occurs is that if we look at the expenses that the World Bank looks at it, there is an enormous gap in a very large distance because what you have in practice and what is advisable. So what do we have? We have an excess. It continues to be very high. It is a very complex, very costly process. There is not really an incentive, a special incentives for the discharge. Well, the judge, Dr. Daniel, will tell you a little bit more about that because now we have this in the law, but there is nothing specific for the small company. And there is a social stigma, enormous social stigma in the country. There is no access to credit, and the insolvency law is not sufficient to deal with the situation. What we do have, and that is the good news, that we are seeing now a change, a paradigm with regards to the small debtor. So what we have are initiatives in other laws, initiatives for finances, for some debtors, especially for rural producers, for example. It is capital market initiatives that are supported by the government at lower rates, and the bancarization process that is starting. So there is a trend to the access, an easier access to credits for the small companies. And another initiative that is appearing, I feel it as if we are starting a process for the people, the individuals who covers the micro and small enterprises in Brazil, because a short time ago, new norms have been customer defense has improved a little bit the situations for the consumers, and they bring the principles of financial education and prevention of indebtedness, and also the possibility of negotiation and compulsory education with the installments in up to 5 years of these debts. But even in this solution, there is no rebate in the principal of the debt. So the figure of the discharge or the removal of the debt or the entrepreneurs, it's very timid. And so there is no clear path for a solution. There is nevertheless an indication of better practices, but everything is very slow. And this is really a concern because the crisis is here. It's here now. It's happening now. And we need something to solve it. The country, there is no trends of an improvement because next year we have the elections for presidents in Brazil, for a president in Brazil. And the law is still very timid. And I believe that we, Dr. Daniel will explain it, I believe, a little bit better. And I think that there is an enormous responsibility on the part of the judges, and they will have to straighten this up because it is not straightened up in the law. These are at least my starting opinions. Thank you very much, Fabiana. Daniel, we are listening to you very carefully. Can you hear me? Yes. Good morning. Good morning, my friend Javier, Fernando, Christina, Andres, whom I hadn't seen and with whom I hadn't talked for a long time. It is very good to be again with you. Fabiana, it is a pleasure to be with you again. Before I start, I would like to send a special with the Superior Court here that is with us here, as well as the judges of the National Forum of Judges of Bankruptcies who are here too with us, assisting to our panel. Javier, if I have time, I would like to tell you about the story of Conan, but if not, it will be left for another opportunity. Well, they are all asking me about Conan, but I think that in another opportunity, I will be able to tell you a little bit more about that. About the micro and small company and the treatment that the Brazilian legislation has for them, for these entrepreneurs, it is important to bear in mind that the Brazilian legislation has a special chapter for insolvency, bankruptcy of small and micro companies. Our law is from 2005. But as Fabiana said already, the procedure has a lot of limitations that transform in is used by the micro and small entrepreneurs. The advantages are very small, minimum, and do not become incentives so that the procedure is used. We had a short while ago a reform in our legislation in 14,210 and 20, and the reform decided not to modify the chapter of insolvency of medium and micro enterprises because that has to be done by a specific law with a lot of more time to decide for us to have probably a more effective and less bureaucratic, more accessible procedure, because this is, in my opinion, the more important factor. It is too expensive and therefore less accessible for them. So the reform has only covered some of the items that are very important for the treatment of the crisis of the small and micro enterprises. I could mention a first item, that is the creation of a procedure, hybrid procedure, procedures of pre-insolvency that is much more accessible, especially for micro and small entrepreneurs, that has a much lower cost, and it is simplified and therefore is very accessible for micro and small enterprises. This procedure operates in this manner. Somebody process a procedure of negotiation, mediations, and a private chamber, or especially an organ by the judicial power, so that there's a mediation and conciliation. Then, with a procedure, extrajudicial procedures, and has the possibility to request the judge a measure or the suspension of the executions, a stay of 70 days. While during these 60 days, the creditors and debtors will be helped by a negotiator or mediator, and if they get to agreement, the judge is going to agree on make it approve it, and then they close it. There is no possibility or renegotiate it or renew the stay. This is a way that they found it, or make a potential the success of the negotiation. Why? Because we have, first of all, a negotiator, a specialized mediator that are acting during the negotiation, and we have a stay that is a very important to the negotiation. So this procedure is not specific for the micro and the small, but it would be appropriate for them. The second point is that it would be inclusively agreement with the principles of the World Bank, is the fresh start, is the possibility of rehabilitation of the entrepreneur. Our new legislation deals in a very easier way of this fresh start. Why? Because before the reform, the rehabilitation could only happen after 5 or 10 years of the closure of the closure. That was a long time, too long. Now the 3 years, up to 3 years after the start of the process. So it is a reasonable time. The good faith could be rehabilitated, could receive the discharge and the possibility to return to the market to start as an entrepreneur. I believe that these two parts of the reform would the crisis of the small and medium or the micro enterprises. And in parallel to this, we have a movement of the majority of institutional funds for the micro enterprises, and who are in charge of this institutional movement is our National Council, Justice Council, who have prepared a specialized department in insolvency and has created many recommendations and administrative norms for restructuring of the judiciary and the judicial administrators for acting better and their agents in the treatment of the crisis. This is really an attempt to work better in the Brazilian affairs. I could the recommendation to the courts for specialized courts in insolvency in order to create the justice who are the the spaces organized to starting the mediation and start the extrajudicial negotiations with the possibility of using this hybrid procedure that I mentioned previously. So when we have the sum of all these initiatives, I believe we are advancing in the treatment of the crisis of the micro, medium enterprises, as well as we also have in our National Congress some draft laws with a specific treatment for the bankruptcy of the micro and small enterprises for the projects that we already know. I believe they are very complex, very difficult, and I believe that the number one that we must have in mind is the simplicity. The procedure must be very simply easy to understand. And I'm especially judge, I have difficulties in understanding. I think there's something wrong in it. And therefore we have time to discuss it and to seminars, panels like this one, I believe are extremely important and useful for a conclusion of an idea based on the best practices around the world. Thank you very much, Javier.
Thank you very much, Danielle. Let's go on to Argentina now. Possibly I guess Christina and Fernando have organized themselves. The idea is that Christina will be able to tell us, based on her extensive experience as a judge of first instance, of what is happening with the small and medium enterprises and the insolvency in Argentina. Good morning, Christina. Hello, Javier. If you allow me to speak more specifically on the topic of what is happening in the courts and to not talk on the legislation or lack of legislation, if we can make a change and let Fernando speak first because of that. Thank you. That way we won't step on each other's toes. Great, thank you very much. So Fernando, please. Thank you very much, Javier. Yes, I believe it is more interesting what Christina will have to tell than what we have in terms of laws, and which is what I'll be telling you. But above all, I'd like to thank you, Javier, Triple I, and the World Bank for this invitation. It's always a pleasure to participate in panels and activities with all of you, and also in this panel with my colleagues and fellow law practitioners and judges. In Argentina, we basically don't have any rules on the insolvency and SMEs. I say nearly because there is something very, very little. But insolvency in Argentina is in law 24,522. In its last chapter, there are two articles which they call small insolvencies and bankruptcies. What this chapter brings us is a definition of what the law considers small, which are defined as those in which the debtor doesn't have a debt equivalent to an amount of 300 minimum wages, which today would represent in terms of US dollars, the official exchange rate, about 80,000 US dollars. So this might be proceedings in where there are not more than 20 creditors with securities or those in which there are not over 20 employees. In any one of these three circumstances, if as a bankruptcy, they are considered a small bankruptcy, and there are some small benefits which we'll be talking about now from a practical standpoint and a relevant standpoint, at least in my opinion. The bankruptcies which are included in this situation, basically there is, at the moment in which the request, the claim is made for the bankruptcy, where the debtor has to present the list of assets and liabilities, there is something which has to be done by a public accountant regarding the assets and liabilities. Likewise, there's a opinion by a legally approved accountant which approves the creditors listed by the debtor, their documents regarding these debts, as well as the lack of other creditors who are not in those records or for which there are no documents. So basically, these are two different opinions or documents issued by an accountant. This represents a cost, but this isn't a benefit for the proceeding itself. And then they are also exempted in the composition of the creditors. And finally, there's an inapplicability in these compositions of what we call the rescue procedures. These are procedures through which, once the exclusivity period is finished, when this exclusive period that you have for formulating the proposals in a bankruptcy, after which, if there's no majority for that to take place, that is when you have to declare bankruptcy. There's an exception to the rescue procedure. That is a procedure in which the judge, instead of declaring bankruptcy, what they do is they open a period for salvage, which consists basically in a, not necessarily a bidding process or the capital of the debtor, if it's a legal entity, which is open to the creditors and to third parties, in which they can participate in order to be able to acquire that capital and therefore continue with the debtor. And simultaneously, there's a new proposal for the restructuring, which in this case, different to the exclusivity period, that is something which will be in competition with the other third parties, creditors or people who make their supplies for exceptions of a capital of a debtor. And above all, the debtor themselves will have a possibility of presenting a new proof, which will not be exclusive, but it will be in competition with those presented by the other participants of this proceeding. Therefore, what the law sets forth in this case regarding the small and medium enterprises is to, in fact, eliminate this rescue process. When one looks at it, this is the first time when one sees that this is contrary to the interests of the small and medium-sized enterprises, because this is an element which is necessary from the standpoint of trying to eliminate a bankruptcy. But I believe that this is something which, in my opinion, the purpose behind this is exactly for the creditors to be more compelled to try to reach an agreement and to try to approve of this because they know that otherwise this company would go directly to bankruptcy, except for the efforts which are made by the judges, which Christina will be able to tell you more about. So those basically are the benefits or the regulatory measures that we have in bankruptcy in Brazil, in Argentina, regarding the small and medium enterprises. Regarding the discharge, in Argentina, there's no specific aspect of the debts on the law, but that is something which appears from a dogmatic aspect, which considers a litigation process of bankruptcy. After this, you have this when the debtor is rehabilitated. This in Article 136 of this law of bankruptcies. where a debtor being an opinion and their members of this administration, where they don't have the rights to the law from the ruling of the bankruptcy regarding the administrators of a debtor from the date of these payments, if this is something that we have starting from this moment. In Argentina, and after the crisis of COVID, as happened in all the world, there were projects in order to be able to have an emergency in terms of insolvency. So we have the experience of year 2000 with a crisis of 2001. And then we had a huge amount of insolvency proceedings, obviously of large and very large companies. But at that time, what was done, furthermore, for the judicial agreements, which I'm not going to go into in detail at this moment, but was to put a stay on deadlines in order to avoid bankruptcies and to give a little bit more breathing room for the companies, for them to have more time avoiding bankruptcies, for them to have more time to recover. This was the only, let me say, reform which took place in 2001, which was temporary. And this was developed in year 2000. Strangely enough, and despite the severity of a situation caused by COVID, and as Andres mentioned, which this obviously is something which comes from the real economy and above all affects the SMEs, who do not have a big capacity to self-finance. There initially was, at the beginning of a pandemic, many projects which were very similar to those, giving a stay, so stopping enforcements and bankruptcies. But in the political agenda in Argentina, unfortunately, that is not part of the priority, at least today, although this doesn't appear to be the case. And so much so that not even this law, this minimal protection, was adopted in Argentina since the beginning of the pandemic. And even before the beginning of the pandemic, we were also working a lot in projects which were related to the topic of SMEs and the insolvency related to them. But unfortunately, some of these interesting projects, but once again, this is not in the political agenda, and this hasn't been minimally approved, this very small temporary solution to extend deadlines and to give stays. And this is not even in the agenda today, unfortunately, considering the situation in Argentina, to have a bigger reform such as what is necessary. Therefore, there's a lot of work on this regard, and Christina and another series of practitioners and Argentina and judges have been working on committees regarding these activities in a very integral manner in Argentina, but we hope that there might be political circumstances in the midterm for this to be able to take place and to have a specific idea and color in Argentina. So thank you very much, Javier. No, thank you, Fernando, for this non-Argentine legislation in terms of small insolvencies. Christina, please give us your vision from the judge's bench. Well, above all, I'd like to thank III, the World Bank, for this invitation to be part of such an honorable panel. And thank you very much to Andres and to you, Javier, for coordinating this panel. So yes, unfortunately, Argentina, the pandemic in Argentina is an additional crisis, a deeper one, if we wish, as it has a global characteristic. But unfortunately, Argentina has a history of a crisis, and every so much time we had the 2001 crisis, as was mentioned by Fernando. We appealed to APE, which is the debt restructuring proceedings, and with very, very good results, because I agree with Danielle that we need to have procedures which are more agile, cheaper, quicker, and that give a better answer to the need both of the creditors and of the debtors to be able to continue with their companies. Unfortunately, as happens in our countries for political reasons, we had a kind of witch hunting effort trying to find strange things sometimes where they didn't exist. And therefore, this is a procedure which I have looked at, and I believe this is a procedure which should be reborn because it gave us great results. What the law does not give us, and we have to try to do this from the courts, for example, to give time to the creditors and the debtors, better said, to be able to restructure themselves and to pay. In Argentina, above all, from the pandemic, we were living an eternal lockdown where one couldn't go out into the streets, one couldn't work, one couldn't do many different things. And that was forbidding the companies to generate money to be able to face their obligations. And therefore, judges waiting and waiting and waiting for the law to extend, to give a stay to payments. That's something that we did as the law was never published. Therefore, we had to try to keep jobs, to try to legislate companies as they could to be able to recover. And for that, the creditors and the debtors needed time. Some not even with time were able to restructure themselves, but some with time were able to do so. Above all, the micro companies that appealed to what we call the big Argentine invention. And due to the big amount of crises we have, we try to solve things in one way or another with what we have at hand. And we have been able to continue at least some, what I see in the courts, several companies. We have not seen, as took place in 2001, and this was mentioned by Fernando, of big companies which were presented as insolvencies, but not a huge number. Yes, there were many micro companies which have been starting these cases. In Argentina, we need undoubtedly, and this is something that we were working with in the reform of the law with the banks, we need credit for small companies given by the banks, because the banks, if a company presents itself what we call in a preventive restructuring measure, Chapter 11, what happens? The banks close their accounts. So to get credit for a debtor which is trying to reorganize itself is expensive, because they have to try to do so using channels which are not so safe, to say it in that manner. On the other hand, we have an IRS which is very hungry in our country, which knows nothing of a crisis and has their own plans. So they don't accept the plan presented by a creditor, but they try to receive 100% of their credits corresponding interests, which they decide, and we prove in the courts, and we reduce it in the courts, otherwise it would be impossible, but they don't study any plan. What do we need? We need the IRS to become an additional creditor, be it secured or to have certain privileges, or to be unsecured for the non-privileged debts, but they just have to be an additional creditor, but not a creditor with super privileges compared to everyone that despite there may be stays, etc. Are there payment plans? Yes, there are payment plans. But what does the IRS require for these? To set up guarantees on the debts, on the debtor's assets. And for that reason, we need to have an important reform from a fiscal standpoint, because what happens many cases is that the majority of the creditors, we need two majorities, those of creditors and of capital, to vote on the plan. We obtain the majority of the creditors, but we don't obtain the majority of the capital because the big creditor is always the IRS. And if the IRS doesn't allow it, that's the liquidation of a company. That's why we urgently need to see a change from a fiscal standpoint. Our main challenge as judges is to keep the sources of jobs as possible. We try to do it. We extend deadlines. We have hearings. We do what is possible and impossible to, in accordance to the law, to be able to make these micro companies be active. We do it for all, but today the majority of insolvencies are with micro companies. And in the case of having to liquidate, we try to do so in the best manner possible, and not an auction, in a bidding process or in the best offer or in any way possible, in order to make sure that the assets value the most amount possible, to pay the biggest amount of creditors possible, and for the majority of the people to leave in the best manner possible. And finally, yes, we need a good discharge system. The rehabilitation system which we have, where the debtor says, that's enough, everything that I want from the year of having declared the bankruptcy is mine, and that's a high pay. That is not a good system. For the creditors, only what interests here, and for 1 year, again, that's what you're responsible for. There are better systems for that. Ours is not the case. Therefore, I believe I've been able to give you a general overview of what happens in the courts in Argentina and the big challenges we have. We try to take into account everything, to call on hearings, to call the IRS, to intervene in companies when we have to intervene, in the case of a reorganization when we see that the administration is not good. And there's a specific case where we saw this in a university where they were able to do this thanks to a correct intervention, because the administration was a disaster. But this is, as if we would call it, we're kind of like an ER doctor that tries to fix the gaps that the law doesn't fix, and to solve the problems which our law does not solve. We need undoubtedly and urgently to see a reform which is in line with the times we are living. Thank you very much. No, thank you, Christina. So I think we have greatly respected the times for the panel. We have what had been mentioned initially. We still have a few minutes for us to be able to, should anyone wish to ask questions to the panelists, or even especially to Andres, who made the introductory presentation on the activity of a World Bank on this topic. In other words, I don't know if the administrators, via platform administrators, will allow people to ask questions, or if questions can be done in the chat box of the platform. Well, as I can see that you're slightly shy, the questions, the initial question, I will, here we have Ariel Dasso from Argentina. If this is a model law as what UNCITRAL suggests or not, or if these are just recommendations, what is being suggested by the World Bank. Andres, please.
Perfecto. Muchas gracias por la pregunta.
Yeah, thank you very much for the question. No, this is not a model law. In the case of a World Bank, these are principles, In the case of Uncitral, these are reforms to the legislative guide. So the issue of a model law compared to the principles or legislative guides, this is a topic, and the question is, what is more useful for the legislators? And in fact, there is no conclusion that is very firm in this regard, because the Uncitral model law on insolvency, on cross-border insolvency, which as very well mentioned by Christina before this call in a conversation we had in preparation, this was something which they tried to adopt in Argentina, and I think even Brazil also in this last reform. But this is something when the Brazilian experts here might be able to answer this better than I do, has been successful in a very gradual manner. And this hasn't been a very simple discussion, but above all, the cross-border insolvency, we may be able to say, is a coordination system. And that's why it was so successful, or relative success, in the model law by Uncitral in this regard. But for the other disciplines, specifically for what are the micro companies or the insolvency processes of small companies, the difficulty of a model law is significant, because you'd have to make something which adapts to the system as a whole for each one of these countries. And this is something which, in adapting it to each national legislation, despite what you have between the model law and the rest of the rules, is not something that we're talking about in this sense. We're talking about this in a substantive manner. That's why we are now at a stage of principles and of recommendations. So this is a little bit of the answer. What I'm going to do immediately now is to get in the chat the document of the principles of the World Bank for you to see, amongst which we have incorporated the SMEs. Thank you very much. Javier, please. So there's an additional question here by Eugenio Costa. I'd like to know, in all the activities which are done by the committees or legislative reform panels, if one calls SME business persons and micro entrepreneurs, those who know on a daily basis, what are the activities that they have with trade unions, banks, and the IRS? Well, I believe that from a personal standpoint, in those projects in which we have analyzed this is something that we have seen. In the case of Argentina, we have spoken to the Argentine Confederation of Medium-Sized Companies, but possibly it's not necessary to consult the business persons, because the professionals and the judges who participate in this committee have the knowledge, or at least in Argentina, they have the knowledge on the difficulties that are daily faced by the SMEs. Obviously, in other countries, we know that this will be something that shall be very interesting, and I am selling you the product of the last panel on the 30th, because Mexico has an insolvency which is very good, but is refractory, totally refractory to the insolvencies of micro, small, and medium-sized enterprises. Therefore, this is a law that is very underused. In the last 20 years, we have had less than 1,000 insolvency proceedings in Mexico, because we only go for the big companies. In the case of Mexico, yes, it would be very interesting for a reform to be this involved of the SMEs. And the crisis is, as we look at this on a frequent basis in Argentina, you go into a preventive measure. And this is something that we see in the Brazilian language, which would be to have the recuperação judicial, as we say it in Brazil. In other words, the reorganization. The issue is if they are or not efficient in the systems we have. The answers that we get to both Andres from a World Bank standpoint, as well as the four panelists, and these are what we have that are not efficient systems and that we need to see a legislative reform. But in Brazil, if someone wants to see the experience, if the reforms, if we have the committees that organize the SMEs, it would be interesting, yes, to listen to them if they have an opinion on this regard. I'd like to add something to this. Yes, I believe it is very important that all those involved in the company's crisis be heard. In other words, we have to hear the judges, the attorneys, the representatives of the IRS, and obviously the business persons, the people who are medium and small size enterprises. So in Brazil, this is something which has been done. Everyone has been heard. So as mentioned, in our reform, there's no specific focus. This is another discussion. This is another draft bill which is moving forward, but there are some aspects of our reform which, yes, are applicable to the SMEs, but they have all been heard, undoubtedly. Sorry, Javier. Yes, can I just make a comment to what Judge Danielle has mentioned? I believe there's a global issue, which is the way in which we prepare laws, right? Because there's a difference in the powers regarding the stakeholders. So I think there's a lot of resistance from the banks and from the financial institutions, and even with the possibility of default. I don't know how to say default in Spanish, I'm sorry, but this is, in one other words, what I'm trying to say is the non-payment in situations when people don't act with good faith. In other words, it is clear that everyone has been heard in this legislative process, but this difference, and this is obviously a conversation, this is something that is a party, obviously all laws are done in this manner. There are representatives from agro-business, representatives from society in general, but I believe it is very difficult to balance the different weights of the opinions in a democratic process. And obviously this is part of a process, but that's what happens in practice. Well, thank you very much. I think we're right on the dot in the time. And there's a very interesting question from Lon Peterson, a friend from Venezuela, that we haven't seen ourselves in a long time. Roland is asking, how ambitious should a country be trying to modernize their legislative insolvency systems? Is it preferable to have a legislative reform in line with the practical adaptations, or is it worthwhile to copy legislative systems which are advanced on this topic and to start to row, to catch up between the gap, the difference that we see in practice and the rules, the normative rules? Any panelists that wish to? Anyone who would like to answer this, please, you're welcome to do so. In my opinion, I don't like to just cover the holes. I'd say I'm very ambitious. I would like to have an excellent legislation, and I'd like to have a catch-up to be able to obtain excellence and not to just go covering small holes, because when we cover the last hole, the first hole that we covered possibly is once again open. So I think I'm possibly too ambitious, and I think I'd like to have the best legislation possible, and that those of us who have to try to answer this, to do the catch-up and to have a legislation of excellence. Yes, I agree. Our friends from Brazil, what is your opinion? I think we have to have a good legislation. We have to have a good tool, but we have to have good application of this. This is a combination. In other words, we have to have legislative reform for us to improve our legal instruments, but at the same time, we have to have an improvement in our institutional environment. This is the idea that we have with the National Justice Council. So at the same time, legislation and improvements from an institutional standpoint. So I see we're right on the dot on the time, and Andres has published the link in order to be able to have access to the materials by the World Bank. So let us wrap up. Once again, I'd like to thank the World Bank in Andres's name, as well as the four panelists, the four brilliant panelists who have made themselves available for this first webinar of the three, which we shall be organizing by III and the World Bank. And obviously, thank you very much to all of you who have participated and attended this panel. I wish you all a very great day, and I hope we are able to see each other again next Thursday to hear the experiences. I believe it is next Thursday with Colombia and Chile, and the last Thursday, Peru and Mexico. In other words, once again, a great day to all. Thank you very much.
Gracias, Javier. Muchas gracias por el trabajo y muchas gracias a los panelistas y a la audiencia. Adiós.
Muchas gracias.
Gracias. Saludos a todos.
Gracias a todos, un placer.
Adiós.